Welcome, welcome, welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast. Big hello to everyone else in between. My name is Dan Balkaran, as you can see on the screen, and I am an employment lawyer at Samfiru Tumarkin, LLP, Canada's leading employee side employment law firm. I am going to be I'll be your employment lawyer for the next 30 minutes, and I'm going to be answering all of your questions about all things employment law. As always, bit of housekeeping. If you need to get a hold of us, you can do so at any time at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, we got one question coming in early. I think some more are about to follow. I'll tackle that first question now. Please send in all of your questions, and I'll try to get through them. Okay. I don't know how to, well, I'm just not going to identify this person. I'm in a separation negotiation with my employer. I told my CEO that my HR person was discriminating against me. He said, "I'm sorry you see it that way." And then no one said anything to me for weeks. Sorry, are you sure you're in a separation negotiation, or are you just working now? It's not clear from your question. So, there's a duty for employers to investigate discrimination if it occurs on a human rights protected ground. That would be like your ethnicity, sex, gender, age, sexual orientation, disability. There's a bunch of them that are defined in either the provincial human rights legislation or federal, depending on if you're federally regulated or provincially regulated in your employment. There's a part two. Hold on, let me finish reading that. So I put in a month notice. 2 weeks in that notice, they blindsided me, said they're accepting my resignation early, and sent me a severance contract, well, an offer, I guess, and froze my work computer. Yeah, if you resigned, so the way severance works is your only legal right in the event of your termination, more or less, is severance if your termination happens today. It's notice or severance if it doesn't happen today. And so, but you don't get that. You don't have an entitlement to severance if you quit, right? If you quit, you get nothing, and you quit. And so, they accepted your resignation. Now, you could perhaps show, and you're certainly going to want to talk to an employment lawyer as soon as possible, that in fact, there was an ongoing separation discussion and negotiation. But if you quit, you might not have any actual negotiation leverage at all, because you quit and you're entitled to nothing. And so they sent you a severance contract. I assume that means they said, well, we'll pay you out X and sign this release. Probably what happened. And talk to an employment lawyer. Certainly, if you want to get a hold of us, you can do that at help@employmentlawyer.ca, employmentlawyer.ca, or 1-855-821-5900. But if you've resigned, then beyond the 1 month of notice, I don't know if you have. It looks to me as if you don't have any claim to anything additional, other than if you can show that the termination happened earlier, insofar as you were negotiating out a voluntary separation package. But I think that's going to be really tough. However, if you have legitimate discrimination, you might have an injury to dignity claim. So human rights damages are divided into, broadly speaking, two chunks: severance, which we'll be talking about throughout this session today, and injury to dignity. Injury to dignity is it's really a sort of an undefinable or poorly defined concept in which your dignity has been affronted by discrimination that you've incurred under a human rights protected ground. And again, that's your age, race, ethnicity, sexual orientation, sex, gender identity, ancestry, disability. There's more. But because of your discrimination, you're entitled to damages for the discrimination you have incurred. And how that's quantified has to do with how vulnerable you are in the moment, and the severity of well, we'll call it the egregiousness of the discrimination. Generally speaking, human rights damages tend to be more moderate, although in some severe instances they can be quite a bit higher. Um, so you still may have that available to you, but you have, because you've resigned, your options you'll find might be quite a bit smaller. And so, just generally speaking, for everyone who's watching this, uh, if you're in a situation where you have a you're probably going to be leaving the company at some point, the terms aren't the best, you don't want to resign. Never resign without talking to an employment lawyer first. I mean, obviously, I'm not talking about in all situations. If you got a better job and you're moving on, then that's fine. But if it's a situation where you're trying to obtain severance, it's a better way to phrase it. If you're trying to obtain severance, um, don't resign without talking to an employment lawyer first, because it may limit your options. Now, for this particular person, I don't know about enough from what he or she posted, about the pre-resignation discussions about her leaving. If she can claim, or he can claim, that if they can claim that uh, they in fact were de facto terminated in those discussions, then that might preserve his or her options. But certainly you're going to want to talk to an employment lawyer right away. Okay, question from, this name is too unique, so I'm not going to say it. What can be done? Just call this person Jay. What can be done if you were put on indefinite leave from your old job? I'm confused. So you're, generally speaking, if you're an employee, or I shouldn't say generally speaking, if you're an employee, what you're doing is you're trading your labor for money indefinitely. Okay, over, forever, until such time as your employment comes to an end. And so the employer has no right, generally speaking, well, it has no right at law to stop paying you. Okay, so there's no right of suspension, there's no right of layoff. Okay, um, unless it's in your employment contract, in which case then there's a limited right of suspension or layoff. Now, what a layoff is it's a temporary interruption of your employment. So no pay, but you're not also giving your labor. Okay, for a time that is limited by statute, either under the Canada Labor Code or your local, Provincial Employment Standards Act, after which time you're terminated by operation of the law. Okay, and so, but there is no ability for the employer to just stop paying you and leave you on a leave indefinitely. And beyond that, it has to clearly indicate that you've been laid off for. So actually, let me finish that first thought there. So there's no scope for them to put you on leave indefinitely, and if that's what's happened, you've been terminated, and you can avail yourself of, severance remedies. Okay, if they've put you on layoff, then again, since if you didn't object to it at the time, then they have the entire then you're on a layoff. You're deemed to have accepted the layoff, we'll say, for a period of time which is prescribed by statute. Okay, so statute can terminate you, after a certain amount of time. So in BC, if you're on layoff for 13 straight weeks, you're going to be, effectively fired at that point. Um, but if they didn't clearly indicate to you that you were on a temporary layoff, it could be that you've already been terminated. So, Jay, you might have severance remedies available to you right now. So you should talk to an employment lawyer right away. Again, if you want to contact us, you can do so. Employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay, the individual we were talking about earlier, who resigned, should I put in a counter offer? Doesn't this show that they're aware of their fault? Again, if you resigned and you don't have the factual basis to claim that you had already been terminated before that, um, you might not have any scope to actually negotiate anything. So you definitely want to talk to an employment lawyer as soon as possible. Um, just to see, you got to go over everything that happened and see if there's what kind of leverage you have for negotiation. A question from AS. What can you do if you believe your employer is committing fraud? Okay, so if your employer is engaging in criminal activity, you certainly don't want to participate in the criminal activity. Um, I'm not. I don't know what your obligation is to report that criminal activity. I do know I've encountered a number of clients and potential clients who have reported to the employer that they thought the employer was committing fraud, and then they were fired because they rocked the boat with respect to the problematic activity. Um, despite, and I'm not familiar with it, but despite any whistleblowing protection legislation that exists, um, if the employer is committed to its problematic activity, um, it's unlikely to reward you for pointing it out. So I don't. There's not a good answer to this question. Um, I mean, do you just lay low and hope that you don't get implicated in it? Do you resign and go work somewhere, or do you go look for another job and then move on? I don't know, and in fact, I'm not going to. I'm going to decline to provide my impression and or opinion on that particular question. I know that's not um, helpful in your situation, um, but it is a very touchy situation when you're alleging that your employer is committing fraud. And I don't know what kind of fraud. I don't know if it's a civil fraud or a criminal fraud or what have you. If it's criminal, do you have an obligation to report it? I don't have any expertise on that to the authorities. And if it's not criminal, um, all I can say is if you report it to your employer, the odds go up that you're not going to work there anymore, right? But from an ethical perspective, should is it something where you're compelled to report, or perhaps you gracefully move on from the company? These are decisions you'll have to make, and certainly I'm not prepared to comment on that at this time. So sorry about that. Brennan asks, I've been told that construction workers don't have the same severance entitlements as other jobs. Is that true? Okay. This is a very good question. So in severance entitlements are divided into your minimum statutory entitlements and the larger common law entitlements. So common law just simply means what a judge decides you're entitled to pursuant to a body of case law which has evolved over decades and decades. So in terms of how much severance you want, common law is much more lucrative. Statutory severance is much smaller. It's closer to 1 week per year of service to a maximum of 8 weeks. Now, in British Columbia, I believe in most provinces, but certainly in British Columbia, if if you're a construction worker who regularly works on construction sites for a construction company, the statutory notice provisions of the Employment Standards Act do not apply to you. So that's probably what they're talking about. However, even with the larger common law, if there's a custom and usage, whatever that means, that of laying you off, if there's an expectation that, for example, you've been hired to be an elevator operator, a skipjack operator, building one building, and then after the building is done, you're not going to work there anymore. Okay, that there's an understanding there that you're going to be fired at the end of 12 months or 18 months or however long it takes to build that one particular job. In that situation, probably not owed common law severance, and you wouldn't be owed statutory severance either. So there is an element of accuracy to that. Now, I've had many construction clients, and if if you're in a situation, Brennan, where you've worked at the company for quite a few years, so it's not just limited to one project. Well, I shouldn't say quite a few, but a few years, not just limited to one project. You work on multiple construction sites, and there's a lot of work available to you. Then probably you I shouldn't say probably, you may have an entitlement to common law severance depending on what's in your employment contract, but you still don't have a right to statutory severance. Okay, so I don't know if this is coming up in the scope of you being terminated, but if you are in fact terminated, you should talk to an employment lawyer immediately, because your matter will be very complicated. So again, if you need to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay, the person who resigned is asking some more questions. They're offering 2 additional weeks on top of the 4 weeks of notice that you gave. Because I used personal time off and was denied the ability to work from home, um, even though they allowed other people in the department to work weeks at time from home. I don't think that's discrimination. I think that if you were unwell or you had a disability or a medical issue that prevented you from coming in the office that was temporary, you may have a discrimination claim there. But did they fire you because you used a sick day? I don't really know exactly what you're getting at there. But they're offering 2 additional weeks. I mean, their offer tells you what they think of the value of your claim, right? They're offering you 2 weeks. It's not very much money. If you counter offer, I suspect that they might squeeze out another couple weeks, but that's probably going to be it. Um, so I like I said, I go back to what I said earlier. I think that by resigning, and again, I don't know all the facts, but by resigning before before your negotiation was complete, you've limited your options, I think, unfortunately. But again, talk to an employment lawyer, find out if your previous discussions if there was a termination that occurred through that somehow, and then maybe the resignation isn't something that's valid, or if you resigned under severe emotion, it was clear that you were very emotional about the situation and didn't intend to resign. That can certainly avail you in BC. But if they're offering you, do I think what you're describing is human rights discrimination without having a medical reason for why you needed to work from home, or if they fired you because you used a sick day, but they didn't fire you, you resigned. So I don't see how there's human rights discrimination in what you're describing. Kathy asks, my employment contract says that I must be available to work at any time, 24/7, 365. I've been in my position on day shift for 17 years. If I switch departments to change jobs, that could mean I could end up on graveyard shift. Can my employer do this? Well, I don't understand from your question. Are you the one wanting to switch departments, or are they switching your departments for you? Like, they're imposing that upon you? Listen, the best way to deal with something like that is, if there's a medical or family reason why you can't change schedules, then get a note from, if it's a family reason, inform your employer. It has to be a good reason. So, elder care responsibilities, or child care responsibilities, that will should prevent the employer from putting you on a graveyard shifts. Medical comes up a lot. So graveyard shifts are something that are very difficult for their bodies to handle, particularly if you're talking about changing between days and graveyards, sort of back and forth. It's one thing if you're working permanently on graveyards, but the switch back and forth, causes a lot of havoc on people's bodies. Particularly, you said you were there for 17 years. Switching back and forth between graveyards and day shift tends to be easier on those who are younger, but it tends to be very, very difficult for people who are older, well, say north of I don't know, 35, 40, And so you could probably just get a medical note saying you're medically unable to work graveyard shifts if and when that comes up. But I'm not clear if you're the one who wants to move to a different department, or if they're imposing it upon you. So, but if you're worried about a schedule change like that, if you have a valid reason, medical or family responsibilities, that can really assist in not having that schedule imposed upon you. But if your employment contract says that you're supposed to work any shifts, then you've agreed to that. So there's it can be a little difficult. Okay, so this is the person who resigned again. She turned in her paperwork from doctor explaining her disability. Needed to be able to allow myself to work from home as needed, but was denied. Yeah, that's a tough one. I don't know if there's been enough decisions, or any decisions really, on from a human rights perspective. If you're because I mean, in BC anyway, I know it's a little muddy in Ontario in terms of jurisdiction with human rights matters, because you can graft it together in your lawsuit, but in BC it's a completely separate jurisdiction. Um, if your doctor says that you must work from home and the employer says no, is that discrimination? Uh, that's I don't know the answer to that question. I don't think that's properly been adjudicated yet through the various human rights processes, and a lot of them have backlogs as well. So the Human Rights Tribunal in BC is quite backlogged, we'll say, at the moment, and so a lot of these working from home cases started with the pandemic and haven't worked their way through the system yet. I'm sure we'll have a body of law on that later on, um, but you know, I don't know. I don't know if a doctor says, yeah, you must work from home, and the employer says no, or says, we require additional. I mean, the smart way to do it would be to say, well, we require you to see one of our medical experts to determine whether or not, in fact, you can work, you must work from home. It's a hard thing, right? Because you either can work or you can't, right? Or you can work with some accommodations, but the medical reasons as to why you must work from home as opposed to the office seem to be from a realistic, common sense assessment to be limited, right? There would I don't even know what they would be, why couldn't the employer just accommodate what your medical needs were in the office? So that's a tough one. That's a real tough one. So is that discrimination? I don't know the answer to that question. It could be. And the reason why I don't know is I don't think that's been considered yet through the human rights processes, because it's too new. Question from John. I got into a disagreement with my employer over shift scheduling and was let go of result. I work as a driver. I was told I was going to receive 2 weeks, but my letter did not include any of this. What sort of entitlements do I have as a truck driver? I've worked there for 4 years. Well, it depends what your employment contract says, right? So if you were let go, you should be entitled to at least, it was 4 full years, 4 weeks uh, of severance pursuant to the Employment Standards Act. If you're in for an interprovincial trucking company, though, then that amount will be different, and the amount that you're entitled to will flow from, and I don't have it off the top of my head, unfortunately, but it'll flow from the Canada Labor Code. So I don't quite have the answer to that particular question. If your contract doesn't limit you, if you're federally regulated, so I'll do this in two parts. If you're federally regulated, i.e., you work for an interprovincial trucking company, then and a lot of them are, by the way, um, then you have the opportunity, or you have the ability to avail yourself of unjust dismissal remedies. Now, you have to file your unjust dismissal in 90 days, so it's very serious. If you miss it, you're probably done, at least for that remedy. But you can file your unjust dismissal complaint, and then you've got, and it's free to do so, and then you can seek back pay, which is the same as severance, or reinstatement. reinstatement can be a powerful remedy because your employer probably doesn't want that and will be willing to negotiate at a higher level, we'll say, in terms of the numbers to avoid that. However, only been there for 4 years. Whatever back pay claim or severance claim that you have is probably going to be moderate, and if you aren't federally regulated, it's going to flow from what your employment contract says. So, probably want to yours is a complicated matter, John. You probably want to talk to an employment lawyer, and you can certainly do so if you want to get a hold of us at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, we're almost done, but I'm going to try to get through these questions. So, the person who resigned is back again. After denying him or her from working from home, they allowed two other people in their department to work from home for weeks at a time due to family members having surgery. That sounds reasonable. Um, so I thought this was discrimination. Well, it depends what your reason for working from home is, right? Like, it sounds like the company was fairly reasonable in saying, all right, well, your spouse is having surgery. You need to be at home to care for your spouse while working. We're going to let you work from home. That sounds fairly reasonable. Now, if your reason for working from home is medically justified, then it might be discrimination. But I don't know what the reason was. Liz asks, what advice can you offer in a constructive dismissal? Wow, the overriding piece of advice I can offer in a constructive dismissal is don't do it on your own. You can't do it on your own. It's too complicated. It's too hard. You have to have a lawyer for a constructive dismissal. So for everything that we've talked about in terms of severance, it's a quantum analysis. You've been fired without cause. Does your employment contract limit you to statutory severance? If not, how much is your common law severance going to be based on your age, length of service, and position, divided by have you looked hard enough for a job? Effectively, outcomes a number. Okay. What a constructive dismissal is that there's one more piece to it. It's that if the parties can't resolve their dispute and it ends up in front of a judge, does a judge think that the employer's actions were tantamount to a termination? Okay, and the actions and the judge is going to make this evaluation based on two tests. Either the employer breached a fundamental term of your employment contract such that you have been de facto terminated, or the employer has indicated through its actions that it doesn't want to be your employer anymore. Okay, and in both of those situations, a judge is really going to put him or herself in your shoes and go, well, would I have been able to continue to work there under in that situation, under what was happening? Because you've got a job, and you're in society, you're in the economy, you are working for money, everyone's paying taxes out of that, and you're asking a judge to say, well, you know what, you shouldn't have, the employer shouldn't have done that such that you've been terminated. It's a hurdle that you've got to overcome, right? And it happens all the time. Lots of constructive dismissal cases, but they're harder. They're a lot harder. And, the different slices of what happened, did the employer unilaterally reduce your salary? Did the employer, by over 10%, or did the employer demote you and hollow out your position? Or is it, just death by 1,000 cuts where the employer just really doesn't want to be your employer anymore? There are different risk percentages attached to each. So depending upon the facts of your situation. So don't do it alone. Do it with a lawyer. It's too hard to do it on your own. How much do we have? Okay, so this is all last person. We're almost done. So Deep asks, I work as a part-time truck driver. I don't want to talk about your medical. Okay, so I take a certain type of therapy for insomnia. I was resting in the truck on my lunch break. I was harassed at work by my supervisor. I reported to my company. They said there was no harassment without interviewing me. They forced me to disclose my medical condition. When I provided my medical note stating that I'm going through what it is that you're going through, they said it's not safe for me to drive a truck. And me and my doctor believe that I'm fit to work. Sure. So your doctor is going to be determinative here. So get a doctor's note saying you're fit to work, provide it to them, um, and you know, that should determine the issue. But the employer has a difficult position here. If you have insomnia and you're a truck driver, and truck driver accidents famously arise in the main from lack of sleep on the part of truck drivers, such that there's been a real push over the last few decades to have legislation and technology that tries to intervene, or it limits the amount of time truck drivers can drive without taking breaks to sleep. And that, camera technology that I don't know if that's the case with you, but that checks to see if the truck driver is becoming sleepy. um, so you can see why they have some concerns. I think that in this case, Sukhdeep, this is out of your hands. I think this is entirely the domain now of the medical professionals. I think you need to get um, I think you need to get a your doctor to write you a note about your ability to work as a truck driver given your condition, and work with your employer on that particular issue, because I do think that there are real concerns that the employer has, and I think that they need to be satisfied from a liability perspective that you're medically okay to work. And I think you got to work with your doctor on this one. Liz comes back and says, it's great advice. Appreciate the fact that you understand. Employers may or may not be aware. Can they defend with being ignorant of the HR code? So HR, I don't know what you mean by HR. Do you mean the human rights code? Um, while you're talking about discrimination, can discrimination be constructive dismissal? I mean, depending on the type of discrimination, certainly. It can be, but you need to talk to a lawyer to find out. Sorry, one more thing, Liz. If it's a situation where your employee, doesn't sound like it based on what you just said, but if your employer imposed a unilateral change on you, breaching your contract, so reduction in your pay, changed your schedule, it's rare, but it should be constructive dismissal, but change in schedule, reduction in hours that you don't agree with, you got two months from the date of more or less from the date of the change to object to it and trigger your own constructive dismissal, or you're deemed to have accepted it. Once you've accepted it, you can't go back and try to use it later to get out of to trigger your termination. So 5 months down the road, you can't say, oh, this was a constructive dismissal. So I'll leave it there. We've gone way long, but thank you all for the great questions today. Again, if you want to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Join us on Monday, October 30th with Chris Justice. He'll answer all your questions employment law then. Until then, I'll see you all in 2 weeks. So until then, have a wonderful and safe weekend.